jurisdiction of the court to grant. And my lords, the circumstances that we refer to of affidavits that were deposed to by the chairperson of the first respondent, those circumstances point clearly to why we could have a reasonable expectation at the time of closing our case that that chairperson would be testifying. We had a completely reasonable expectation of that based on her own affidavits, which are in effect sworn statements. And my lords, these sworn statements actually have very precise legal effect in terms of the evidence laws of this country. In Section 26, in Section 26 of the Evidence Act, it is provided as follows: except as otherwise provided by law, including a rule of equity, when a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest and such relying person or his successors in interest. Now, my lords, the effect of this conclusive presumption is also provided for in Section 24 of that Evidence Act, where the basic facts that give rise to a conclusive presumption are found or otherwise established in the action. No evidence contrary to the conclusively presumed fact may be considered by the tribunal of fact. My lords, this legal position, as far as the effect of what was in the affidavits of the chairperson of the first respondent is concerned. This legal position was also recognized by this court in the case of Sefa and ASAASE number 2 against the Bank of Ghana number 2. And JMFI number 2 and Bank of Ghana number 2 consolidated. But if we can just, the citation, my lords, is 2013 to 2014, 1 Supreme Court of Ghana Law Reports at page 530. My lords, this was a decision of this court comprising His Lordship and in your word, Justice of the Supreme Court as he then was, and Justices Bafuboni and Badegbe, Justices of the Supreme Court. And their lordships reversed an order of a single justice and in reversing that order, the lordships made reference to the terms of this Evidence Act. And Justice Badegbe, whose decision was agreed to by the other lordships had this to say at page 539. By the operation of the effect of the depositions made in the application before the High Court, the applicant, that is, the Respondent Bank of Ghana, is caught by Section 26 of the Evidence Act, which is commonly referred to as estoppel by own statement or conduct, as provided for in NRCD 323 in the words that follows. And he quotes what I have already quoted. And continues, since the said paragraphs 6 and 7 give rise to a conclusive presumption within the scope of Section 24(1) of the Evidence Act 1975, NRCD 323, the court which heard the application for leave to adduce further evidence ought to have come to the conclusion that the facts in respect of which leave was sought for evidence thereon to be led in the appeal had long been available to the applicant Bank of Ghana since the making of the application to set aside default judgment in the matter on 18th July 2012. And then they proceed to quote, Justice Gwadegbe proceeds to quote Section 24 and then says, further, in our view, as the application to the trial court was prior in making to that made to the Supreme Court for the purpose of obtaining leave to adduce further evidence in the appeal herein, the inconsistency between the two depositions must adversely affect the credit to be placed on the subsequent deposition, and so on. So, my Lord, the point that I'm making respectfully is that in this decision of the Supreme Court, your lordships determined that statements in an affidavit that had been filed in respect of these proceedings established a conclusive presumption which could not justify exercising a discretion to grant leave to adduce evidence. Now, in this case, we're saying by parity of reasoning that we have a situation where the chairperson of the first respondent has in affidavits made clear that the petitioner would in no way be prejudiced because the questions that the petitioner sought to have in interrogatories, those questions could be the subject matter of cross-examination. And my lords, obviously by that time, she had filed a witness statement, and she clearly intended and expressed that intention to testify. And my lords will see that in the statement of case of the first respondent, the statement of case filed by first respondent in opposition to the application for review, and that is one of the attachments to our application, and I believe that it is marked yes, it is marked recall
Chikata.
Yes,
Mr. Chikata.
yes, my lady.
Kindly clarify something for me.
Yes, my lady.
You want to reopen your case for the first respondent to testify as a witness?
My Lord, not the first respondent. We want to seek to reopen our case. And my Lord, as I indicated, we are not seeking leave to serve a subpoena. The serving of a subpoena or the right to serve a subpoena is provided for under Order 38, Rule 10. The person that we intend to serve the respondent, to serve the subpoena on, is the chairperson of the Electoral Commission, the returning officer. That person is not the same as the first respondent, evidently. But that is the person that we intend to serve the subpoena on. It's not on the first respondent.
All right, so she is coming to testify in what capacity?
She's coming to testify on the basis of the subpoena.
But you
She's
said...
coming to testify on the basis of the subpoena because she's a public official. Milady well knows that subpoenas are very often used in the context where, for instance, a public official who may not wish to be identified as testifying, so to speak, as a witness of one party or the other, but who can be subpoenaed so that in their independent capacity, they can bring to the court matters which are relevant to the determination that the court is making. Subpoenas are generally set.
I asked this question because of your paragraph. Paragraph
15.
Yes.
1-5.
Yes. It said, as a result of the ruling of the court of Thursday, 11th February, it has become necessary, I'm advised and verily believe, that my counsel use the subpoena powers of the court under Order 38 Rule 10 of CI 47 to compel the attendance of the chairperson or first respondent to appear and testify. So you subpoena her to come and testify in what capacity?
As a witness.
Of the first petition.
I'm not sure
of the
in what capacity. She's a witness.
Witness of who? The court or the petition?
No, she's our witness, but as the evidence law allows, she is treated as an adverse witness, what in common law was referred to as a hostile witness.
You want to treat her as a hostile witness? Assuming your application is granted, you intend to treat her as a hostile?
Yes, that is what we're saying, naturally. And my Lord, respectfully, at this stage, her status as a hostile witness, adverse witness under the Evidence Act, at this stage, that is not an issue before you.
No. So it's totally an issue, you see, because we have to exercise our discretion to grant or refuse your application. And we can only exercise our discretion on extremely appropriate grounds. We need to know what she's coming to do, whose witness is she going to be? And
my lords,
the capacity is important.
She is coming as a witness of the petitioner described in the evidence laws of Ghana as an adverse witness, and in common law described as a hostile witness. That is the capacity in which she is coming. When your ladyship asked in terms of capacity, I was not very clear what capacity meant. But in this context, it is as an adverse witness. That is the capacity under the laws. And my lords, I was also alluding to the statement of case of the first respondent, in which, and that is exhibited to our affidavit as part of Recall 1, and it's exhibited Recall 1. It's exhibited as part of Exhibit Recall 1. Exhibit Recall 1 consists of the affidavits in opposition to a motion or notice for review, as well as the statement of case that was accompanying that application. And in the statement of case, which I was referring to, counsel states at paragraph 4, the petitioner does not suffer any injury to his rights if the application is refused, as he still has the opportunity to solicit the same answers during cross-examination, unless it is his case that he does not have the full complement of his case and needs the answers to fill in. So here is counsel for the first respondent stating clearly that we do not suffer any injury. The petitioner does not suffer any injury to his rights if the application is refused for the reasons that are given. And that is exactly what Mrs. Mensah herself states in her affidavit. So, my lords, if on the basis of that position that we found ourselves in, where there had been clear representations that this person was actually going to come and be available for cross-examination, it was within our rights to rely on that representation, which has, even under the terms of Section 26 and Section 24 of the Evidence Act, been determined to be a matter of conclusive presumption. And my lords, the reason I sought to separate this stage, where we are simply applying for leave to reopen our case, from the stage of the subpoena, and your ladyship is entirely right that you do want us to be candid with you about why we are going to subpoena her, so that you can exercise your discretion appropriately, and I fully understand that. But the distinction that I wish to make, just for the sake of clarity, is that once, if your lordships grant us leave, and we filed a subpoena, which is then served on her, that is not the end of the matter, because it is still open to her, for instance, whether for human rights or any other reason, to make an application to the court and say, I should not have to come and be cross-examined or be treated as an adverse witness. She would do that by invoking a witness privilege of some sort. And, my lord, that is a process that your lordships are very well aware of. It's a process that was described quite fully in the Supreme Court in a case called Chachuchikata against the Republic. 2011, one Supreme Court law report at page 1. And the Supreme Court there goes into the issues of how a particular witness raised a claim of privilege and how it was dealt with in the courts below, and the Supreme Court then deals with that. So we are clear in our minds that indeed it will be within her rights. I mean, protection against self-incrimination or whatever it is, it would be up to the witness to make that claim and put it before the court. And naturally, the court would, as happened in that case that I have referred to, the court would hear what we have to say. In that particular case, the lower courts actually allowed the witness a privilege, or an immunity rather, an immunity in that case. And the Supreme Court overruled the lower courts and said that that claim of immunity was not well grounded. So it will be open to her to take whatever step she felt appropriate. But my lords, in our respectful submission, this is a witness who, in fact, has every reason to accept a subpoena and to come and testify in order to vindicate herself and her role. This is a witness who has every reason to do that. Of course, it's her judgment as to what steps she takes, but I wish to submit respectfully that this is a witness who has every reason to vindicate her role and her office by coming to testify in these proceedings. My lords, as we have previously indicated, this is a witness who gave glory to God for what she was doing. And appropriately, in our view, it would honor that God that she gave glory to in making her purported declaration if she would come forward as a witness of truth.
Yes, the application.
My Lord, the statement that I'm making is I would honor that God if she would come forward as a witness of truth.
But Mr. Chikata, you know the exercise has a purpose. Everything we do in court must have a purpose.
Yes,
and excuse me, please, must have a foundation and must have a premise, must have a purpose, must have an objective.
Yeah.
So our only interest, and now when you talk about speaking the truth, etc., totally at large, our interest is the focus direction. And what is your focus direction? That's what we are interested in. Or you don't think we should be interested in focus direction?
Milady, it is not at all at large. Right. Because, milady, in these proceedings, counsel for the first respondent, obviously on the basis of instructions from her, has challenged the truth of witnesses that we have put forward and the account that they are giving of interactions with her. Counsel has challenged the truth of what those witnesses are saying. In particular, in the case of PW2, Dr. Pesa White, counsel incessantly put to him that the accounts that he was giving of why they left, why he and PW3, Mr. left the premises, had to do with instructions that they received from her. Counsel challenged this. Counsel challenged the truth of what the witness was. The witness several times had to say, but why would we leave our bags there? Why would we do that? You know, if this was not the case, why would we do that? And counsel for the first respondent put to him that he wasn't there in the meeting. Then we had Mr. Mesonunu also come to testify. So, my Lord, the truth of what happened in terms of these interactions that took place on the 9th of December before the declaration, the truth is essential. And it would honor the God that she serves and she glorifies if she would come and testify as to the truth. That's what we're submitting.
Can we just limit ourselves to the affidavit? Let's limit ourselves to the affidavit in support of your application. Limit ourselves to the affidavit. Let's limit ourselves to the affidavit.
In the affidavit, we have made quite clear that this truth is very crucial. We've made it very clear.
But as to the God that he serves and all that, I think that we should not.
My Lord,
I don't think it is appropriate.
Lord, that was in a declaration that we can all take judicial notice of. I mean, and my Lord, I do not say that in a light vein. I do not say that in a light vein. I say that actually in a vein of solidarity with giving glory to the God that she serves. I say that in that vein, not lightly at all. And I say that that God is a God of truth. And it would honor that God if she would come forward to testify to the truth. And my lords, in the affidavit, in paragraph 21, furthermore, in the proceedings to date, counsel for first respondent has challenged the testimony on oath of my witnesses, including testimony provided by PW2, Dr. Pesa White, Dr. Michael Pesa White, that Mrs. Jinadukwe Mensah had in a meeting with PW3, with Sir Robert Joseph Metalunu, who also testified as PW3, sent the two witnesses who were serving as my agents at the National Collation Center, popularly referred to as the Strong Room, to go and deliver a message to me, with the promise that she would have a dispatch rider go and escort them back before she would make a declaration. My Lord, that's a matter on which that's a matter on which hearing her address the truth of that is important, because as the affidavit goes on to say in paragraphs 22 and 23, counsel could only challenge the witness's testimony.
I want for the specific paragraphs you are.
Paragraph 21, and then now I'm moving to paragraphs 22 and 23.
I thought you stated earlier that the process should be divided into two, and that at this stage we are really dealing with whether the petitioner should be granted leave to reopen his case. I think it would be advisable if we stick to that one. If that is granted, then we could deal with the issue of subpoena and the truth and all of that. So I think it would help if we stick with the distinction that you yourself drew earlier.
My
Lord, we should limit this to whether or not you should be granted leave to reopen your case.
My lords, I am grateful for that indication. Suffice it to say that I moved a little bit beyond that premise because of the issue of the discretion, the basis on which your lordship will exercise the discretion. And so we have, in all candor, to put before you what we are going to do if you grant us a leave. That's the only reason. And then when the issue of...
I think
that's sufficient. Very well, very well. My lords, we will be guided by... And I mean, I'm pleased to see that your lordships agree with the distinction that I made in the first instance. Because, my lord, indeed, my respectful submission is that at this stage, there is a sufficient basis from the circumstances that arose on, I believe, the 9th of February when we closed our case. And when there was the expectation that the chairperson of the first respondent would actually come and testify on behalf of the first respondent. And my lords, I believe it goes without saying that on that day, your lordships, the Chief Justice himself, expressed some surprise at the turn of events, and for that reason asked us to come back the next day in order to address your lordships fully on the legal issues that arose. So, my lords, taking the cue, I now proceed to respond to the affidavits in opposition that were filed apparently yesterday with some Valentine's Day to us. And my lords, in the affidavit of the first respondent in opposition to this motion, it is my respectful submission that there is unfortunate confusion as regards what the issues in this application are. That confusion includes claiming that we are here trying to review or appeal against the ruling of the 11th and so on. My lords, we're not here for that purpose. We've intimated that we are filing a review application as well, and we are within our rights to do that. But we're not here for that purpose, as suggested. And there are various claims which I do not wish to go into, because claims about vested rights which your lordship pronounced on and so on, which, frankly, are wrong. Your lordship did not, to my hearing, talk about vested rights, and I've gone over the ruling several times. But, my lord, the most startling passage in this affidavit in opposition is a passage in which the chairperson says something to do with disqualification. My lords, I wish to quote the exact words of that passage. Yes, that's what I want to. That's what I wish to refer to.
ASAASE Radio.
Paragraph 24. Paragraph 24. Again, I am advised that a subpoena is issued to a person, not to a party, to testify on whose behalf it is issued. First respondent is a party and disqualified, and so am I. We take it a bite at a time. First respondent is a party and disqualified, and so am I. My lords, the rules about qualification to be a witness are provided for in section 58 of the Evidence Act, as well as section 59. Section 58 reads quite simply, except as otherwise provided by this decree, every person is competent to be a witness, and no person is disqualified from testifying. I shudder to think where she got her disqualification from testifying as a witness from. First respondent is a party and disqualified, and so am I. My lords, section 58 does not make that possible. Section 59 goes on, and that is a section about disqualification. So perhaps we can look for some guidance. A person, 59.1, a person is not qualified to be a witness if he is A, incapable of expressing himself so as to be understood, either directly or through interpretation by one who can understand him. I don't think we have any doubt that the chairperson is a person who is very capable of expressing herself so as to be understood. Then B, and I just read the beginning again. A person is not qualified to be a witness if he is B, incapable of understanding the duty of a witness to tell the truth. My lords, if any witness or anybody wishes to rely on that on behalf of the chairperson, they are welcome to do so and to claim to this court that of understanding the duty of a witness to tell the truth. But these are the disqualifications mentioned in section 59. The final one, which is 59.2, a child or a person of unsound mind is competent to be a witness unless he is disqualified by subsection 1 of this section. When a child is competent to be a witness unless disqualified under those provisions. So, my lords, I cannot imagine what this basis of disqualification that is so brazenly thrown in our face in paragraph 24 is about. And it goes on even more remarkably. A person subpoenaed is punishable by committal. What does that mean? I mean, a person who is subpoenaed is not punishable just by being subpoenaed unless they don't tell the truth. If they don't tell the truth, then of course they may face some consequences. And then finally, I am advised that the decision of this court renders the proposed subpoena irrelevant. My lords, with the greatest respect, my lord, not only is it a question of law, the point I'm making is that these claims about committal and so on, they arise in the second stage that we are talking about, in the second stage, not at this stage. And therefore, your lordship should not countenance what is in the affidavit.
But Mr. Chikata,
yes.
Is there your proposal that we should rule on this quote-unquote first stage before you submit your you bring your submissions on the second stage?
No.
Is that your proposal?
No, my lady, that is far from my submission. My submission is, we are asking.
So you're presenting everything.
That I'm guided also by the...
Because you brought an application, and we must give one ruling on the application.
Absolutely. I don't expect more than one ruling. And all I'm saying is that there's no need to go into all the issues related to the exercise of your discretion to the extent that they have to do, with what the testimony is going to be about. I mean, I take that point, that be about, it would not be appropriate for me to start going into all the details related to that, even though they are going to be important and they are important parts of the exercise of discretion, but we have set them out. And I've decided I will not go into that into too much detail out of deference to the cue from your lordship. So, my lord, I'm not expecting two decisions. I'm fully expecting that there will be one decision, and I'm saying with the greatest respect that if that decision enables us to reopen a case, what we intend to do is to file a subpoena. That's all. That is basically, what brings together the two elements of what I'm saying. We will file a subpoena, and at that stage, whatever ground of disqualification she wants to bring forward would be a separate matter. I cannot be arguing about the ground of disqualification at this stage. I just draw attention to the fact that in her affidavit in opposition, she seems to be talking about some ground of disqualification which is not consistent with the laws of evidence of this country. Now, before moving on to the affidavit in opposition filed by the second respondent, I am bound to draw attention again to just a couple more paragraphs of the first respondent's affidavit in opposition. That's paragraph 23, where she says, I'm opposed to the petitioner being granted leave by this honorable to reopen a case that he closed of his own volition and without compulsion. I'm advised that even if this court grants leave for the petitioner to reopen his case, it ought not cause a subpoena to issue against me because a subpoena is issued with coercive effect. And this is a total misapprehension of the operation of Order 38, Rule 10. Because we are not asking you to cause a subpoena to be issued against her. That's not what we are here for, as I've stated quite clearly. All we are here for is to ask for us to be allowed to reopen our case. And my lords, in paragraph 17, the chairperson says, the petitioner entered into the contest herein, believing hoping that he would testify if need be. It became clear too soon that the petitioner's case drifted into departures from the strong room by the petitioner's agent of his own volition and grievances that I had served without biscuits to the petitioner's agent who had left the strong room to be in my secretariat. Well, I mean, the evidence in question came from cross-examination by counsel for the respondent. And to talk about grievances or being served tea without, my lords, respectfully, that is such a lack of truthfulness in terms of how the evidence in PW3 did not express a grievance that he had only been served tea and not biscuits. PW3 did not express a grievance. He was asked a question and he answered very truthfully. Yes, I was served tea, but there were no biscuits. I mean, but my lord, for the chairperson to descend into such triviality, which was brought on by cross-examination of her own counsel, that just shows the depths to which she has sunk.
My lord, the greatest is...
Excuse me. Mr. Chikata, the practice is that you lawyers draft affidavits for parties, deponents in general, whether it's a party or whoever, yes, in applications. So please don't let us go that far. It may be councils.
Beyond that, Mr. Chikata, I would advise that you withdraw that statement. It's not.
My lord, I withdraw the statement about the depths to which he has sunk. I withdraw that statement. And in place of that statement, I would respectfully say, very well. Well, just to say that a paragraph like that does not suggest an adequate understanding of the issues which we raise in this application. Just to say that, and I'm sorry that I used unduly strong language. And I apologize to the chairperson of the first respondent. Now, my lords, my point, however, is that this affidavit of the first respondent rather than seek to offer the Lordship a reason why
radio
question to us to open up the result to attacking unfortunately.
radio
to make that point, but I just draw your attention to that and avoid being provoked. Get me into trouble. My lord,
radio
respondent. Is from Kweku, a lawyer. And my lords will see that in paragraph
Join Prince Moses on ASAASE Business PM with Felix, Oswald, Josiah, and Kweku every Monday for Tech Talk, a dive into our digital world where we bring you solutions, cheeky critiques, features, and analyses of all things tech. We need a woman on this show, don't we?
Business PM from 6 to 6:30 p.m. on weekdays on ASAASE Radio 99.5.
We're not asking to adduce fresh evidence in the sense that you do in an appeal scenario, where, as a matter of discovery of new facts, you put before the Court of Appeal that we have found new facts and we're coming. That's not the nature of application. The nature of application is, very precise. It is to reopen our case on the basis that we acted on the basis of certain representations. In our view, the chairperson of the first respondent was not even entitled to resign from those representations, but she appears to have done, and we are simply saying that we wish to reopen our case for the purpose that we have intimated to this court. And my lords, it is our respectful submission that the first respondent and his chairperson should in fact be the people who, on account of a community of interest with the Constitution of the Republic, would jump at the opportunity to come and give an account of their stewardship. The first respondent and his chairperson should be the ones who would want the world to know that they exercise their stewardship in accordance with the Constitution, by reference to due process, because there are allegations of lack of due process. And there is even evidence from cross-examination by counsel for the first respondent. There is evidence that he brought in about vote padding, for instance. There is evidence which he brought in about material on the pen drive that was in evidence from the petitioner's first witness, which testified to vote padding. Now, my lords, indeed, before I conclude my submissions, we respectfully would ask that we play the videotape which we have put in evidence of Mr. Mark Menu indicating very clearly that in his view, not in his view, just indicating very clearly that when they come to court, there will be testimony about vote padding in favor of the petitioner. Now, madam, the reason why this is really rather critical is because we would imagine that this chairperson of the first respondent would want to disabuse the minds of the people of Ghana of any suggestion that there had been such grave malpractices in the context of the election that she supervised. And my lords, we have her testimony. Well, I'm sorry, not her testimony. We have, because we don't have her testimony yet. We have her counsel putting to a witness. And my lords, clearly, when your counsel puts something to a witness, it must come from your instructions. Otherwise, the counsel is acting unprofessionally. That's what our rules say. So when her counsel puts evidence of vote padding and gets confirmation from a witness of that evidence, well, this is a serious matter because it affects the whole issue of the rights of voters to have a credible election with results that are declared in accordance with valid votes and all that. And yet we had that situation where counsel put to the witness, and counsel did not only put to the witness those allegations of vote buying, counsel put to the witness also allegations that for one regional collation in Eastern region, there were 2 collation sheets. And counsel sought to go into that, which I will not go into. But my point, respectfully, is that counsel, in fact, in doing all that, counsel is really the one who has shown clearly the importance of the testimony of the chairperson to address these issues. My lords, we also had the testimony which showed, again in response to a question from the bench, which showed that the form which ostensibly, the Form 13 so-called, which ostensibly the chairperson had acted on prior to a declaration, was not in fact the form that is provided for in regulation, in CI 127. That testimony was before this court. And my lords, it is respectfully only fair for the chairperson to have the opportunity to admit or deny that important piece of evidence which came from PW2 in answering a question from the bench. It is therefore our respectful submission that none of the points made in the affidavits in opposition provide a justification for our not being allowed to reopen our case, and therefore that your lordships, in the interests of achieving substantial justice, as your lordships have often expressed, you allow us to reopen our case on the grounds that we have urged and for the limited purpose that we have urged before you. My lords, we are opposed to this application to reopen the case of the petitioner. Lords, we have filed an affidavit in opposition, and Lords, we rely on the depositions in the affidavit in opposition. My lords, this application has been filed following the ruling of this court on the 11th of February 2021. Laws, I believe that, therefore, Canada demands that the petitioner would, in deposing to the reasons, assign the appropriate reasons to the court. Lord, may I kindly refer you to paragraph 11 of the affidavit in support. In that paragraph 11, it is being alleged that the reason which the court gave was basically that, let me just read it. In respect specifically of the witness statement filed on behalf of the first respondent, the court decided that since she had not been called as a witness by the first respondent for her witness statement to be admitted in evidence, she would give an oath she was not available to be cross-examined. Lords, I have read the ruling of the court. Nowhere did the court say what the petitioner has said in paragraph 11 of his affidavit in support. Indeed, my lords, what the court said was that, with your kind permission, simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondents to enter the witness box to be cross-examined. So the reason the court gave is there that the petitioner is attributing another...
Mr. Menuvo,
yes, ma'am.
You cannot cross-examine a person who has not testified in chief.
Pardon me?
A person who has not testified in chief cannot be cross-examined.
Yes.
And this person had not even testified in chief.
Yes, your ladyship, but the point I'm making is that a reason is being assigned by the petitioner.
I appreciate the point I'm making. What I'm saying is that it seems to me to be a strange argument, because you cannot even talk about cross-examination when there hasn't been an examination in chief.
Your ladyship, where a supplicant, an applicant before the court, makes false statements to support his application, I believe that it is only fair that counsel will point out those false statements to the court. That is my submission, that the court assigned reasons in its ruling of 11th of February, and it shouldn't be what he has said in his affidavit in support. My lords, I do not think that it can be claimed that we made a false statement. My lord, there is an account given of your ruling. Counsel is entitled to give a different account. Ultimately, it is for your lordship to determine whether what we have said. But to say it's a false statement that we have made in the affidavit, that, my lords, is not acceptable.
Well, I will draw the word false. It is an incorrect statement. My lords,
it's a deposition. It's a deposition on oath.
Yes, my lord. My learned friend was saying that my choice of word false, and that is why I said it is an incorrect deposition. Deposition, I get the correction, my lords. My lords,
or it doesn't reflect what?
Yes, my lord. Yes, lords. A perusal of paragraph 13 and 14 again creates the impression that the court ruled in those matters that's in the review, in the interrogatories, on the basis that the first respondent chairperson will be available to be cross-examined. Lord, again, with your kind permission, regarding the ruling of the 11th, this is what my lordship said when that argument was made. We are also of the opinion that the filing of affidavits in interrogatory applications with the position that the deponent will be available for cross-examination does not make the deponent compellable to adduce evidence at the trial. As already stated, learned counsel for the petitioner only referred us to an affidavit deposed to by the chairperson of the first respondent in opposition to an interrogatory application to serve interrogatories. That affidavit is not evidence in this petition to enable us compel the first respondent to mount the witness box. So again, my lords, on the 11th of February, the court was very clear in its ruling. My lords, in paragraph 16, the petitioner deposes that representations were made by me, or for that matter, the first respondent's chairpersons to him. Lords, I think that is a very unfortunate statement, simply because the petitioner decided on his own to take the steps that he has taken in this matter. The petitioner, first of all, did not obey earlier orders of the court. And then when he obeyed the orders, he filed 2 witness statements. And then the petitioner subsequently sought leave of the court to call a witness. Then the petitioner decided that in spite of the fact that I had intimated in my petition that I was going to call 5 witnesses, I am limiting myself to 3. I closed my case. How petitioner will now see to say that it is as a result of misrepresentations that were made to him that he closed his case, I cannot fathom.
Hello, respectfully, I never said misrepresentations made to me. I never said misrepresentations.
Yes, Lord. Lords, he said representations. I corrected representations. Lord, again, paragraph 20 of the affidavit in support refers to a matter that this court ruled upon on the 11th of February 2021. This is what the court said on that. That is on my Lord, paragraph 20, where
constitutional rule, the first respondent, please.
Yes.
Are you not talking to via paragraph 20?
Yes, so my Lord, via paragraph 20. Yes, my Lord.
Constitutional rule.
Yes, my Lord, and my Lord's ruled on it, made a pronunciation on it.
You see, this application is not for review of the decision. And technically, in all substance, it is not for review. The case has been closed by both parties, and they are seeking the leave of the court to reopen. If I understand what the motion stands for.
Yes, my Lord.
Yes, so please address it. This is paragraph 20 is just the constitutional rule.
Well,
the first respondent is deemed by law to play.
Yes.
You can well, it's your case, but I think it is better to maybe place emphasis on it.
Well, Lord, with respect, I move on. May I refer your lordship to
Mr. Manuvo?
Yes, my Lord.
I mean, what my Lord, the Chief Justice, is saying is address us on why the petitioner should not be allowed, not be granted leave reopen his case. That is what we want to hear.
Yes, my lords, I will come to that. But for example,
you are taking too long to get to that. That's what interests us.
Very well. So, lords, I take it that the paragraph 25, which is an untruth about what happened regarding pen drives. I think that in fairness...
you see, just like I drew Mr. Chikate's attention to, we only function with law here. So, first, my Lord Mafusa asked him what rule he was coming under. Then I asked him the grounds on which he wanted us to exercise our discretion. These are the things that we are interested in. So when you oppose it, tell us why we cannot grant this application or should not grant this application. And then the cosmetics can be dealt with later.
Well, my lords.
You see, you have spent some time seeking to attack the positions in the affidavit in support of this application. Yes.
Well, my lord, I would move on. Lord, it is my submission that this application is not warranted by any rule of law or by procedure. And lords, this court is primarily not a trial court, and therefore we may borrow from Rule 5 of CI 16. And Lord, if we borrow from Rule 5 of CI 16, the closest, yes, my Lord, Rule 5 of CI 16, which permits a court to go and look elsewhere. Lord, the closest that, yes, my Lord.
Is it not a settled practice that a case can be reopened in appropriate circumstances?
My lords, it is a settled practice, but there are circumstances.
Yes.
And so, my lords,
go there. That is what we want to know. They have argued at length that they want to reopen the case, and it is permissible in law. So you satisfy us in a position why the application ought to be refused, because this application technically is directed against you.
Yes, my lord. My lord, with
yes,
respect,
they also closed their case. They have. I'm talking of the second respondent. They also have a role to play, but they are not suggesting in the list that if the case is reopened, they are going to serve the second respondent to come from the Jubilee House to give evidence.
Yes,
have they said so?
My lords. Well, I take a cue. My lords, the view I hold is that if I appear before the Supreme Court,
it is the court which is inviting you to address us on some material which is agitating our mind.
Yes, my lord.
Yes.
My lord, so I will plead with your lordships to refer to a high court decision, which I know is not binding on your lordships, but with the greatest respect, it will help throw light on the circumstances under which a court will permit a party to reopen a case. Now, may I refer your lordships to the case of Annabelle versus Obosu and another, 1982-83, Ghana Law Report. Annabelle versus Obosu, OBOSU and another, 1982-83, Ghana Law Report 585. Lord, in that case, there was an application before Osefri J, as he then was. Lord, this was to reopen a case after the parties have closed their case. Now, His Lordship, in deciding whether or not to grant the application or refuse it, relied on the case of Young versus Kershaw. Young and the versus Kershaw. Kershaw, Kershaw. And Burton versus Kershaw, consolidated. $18.99. 81 LT NS 531 at page 532. It's a Court of Appeal of the English courts which Osefri relied on. With your kind permission, my lords, I read. It is a matter of greatest importance and has always been so treated by the courts that all material evidence which could, with reasonable skill and diligence, be produced at the trial shall be the only evidence which can be considered and must be adduced at the trial. It is obviously in the public interest that parties who have gone through the ordeal of litigation and have had their rights settled at the trial should not afterwards be allowed to patch up the weak parts and fill up the omissions in their case by means of fresh evidence. It is true that in special and exceptional circumstances, a new trial has been granted because new evidence has been discovered. But the rule which permits that to be done is fenced round with many limitations. The party asking for the new trial must show that there was no remission on his part in adducing all possible evidence at the trial. Then again, as to the class of new evidence, the rule is that the new evidence must be such that if adduced, it will be practically conclusive. That is, evidence of such a class as to render it probable almost beyond doubt that the verdict will not be different. And so, my lords, it's my submission that just as in Young versus Kershaw, this petitioner, with very competent legal representation, elected of his own volition to close his case, this should not afterwards be allowed. He should not afterwards be allowed to patch up the weak parts and fill up the omissions in his case by means of fresh evidence. And the only reason is that I wish to call the chairperson of the first respondent, who is the adversary, into the box by way of subpoena. My lords, this whole process that has been filed is an abuse of the court's processes, my lords. Lords, with greatest respect, I have gone and done a bit of research all the way back to 1876 when we received the common law in our jurisdiction. I have not come across one case where a party closes his case and then he is seeking leave to reopen the case only because he wants the adversary to enter the witness box for him. Because it totally will collapse our adversarial system. Because we ask ourselves the question, assuming that this application is granted, does that mean that the court will now open the floodgates for the first and second respondents to give rebuttal evidence? Because it is just going to abuse the process, and it does not augur well for the determination of this matter, a specific matter under Article 64(1) of the Constitution and CI 99. Well, for example, the motion is titled an application to enable, if I got it right.
No, it says motion of notice for release.
Yes, my lord.
It's a court of record.
Yes, I'm coming to read it. It says motion of notice for leave to recall the case of the petitioner to enable reopen the case of the petitioner to enable the chairperson. My lord, the key word is enable the chairperson of the Electoral Commission to testify. My lord, this alone, the title alone of the motion should be a ground for a refusal of this application on grounds of abuse. My lord, well, the body says something else. He says that upon serving a subpoena. Lord, I believe that if I refer your lordship to Order 39, Rule 5 of the High Court Civil Procedure Rule CI 47, the rules attach pain of punishment, among others, where a subpoena is served and you don't take certain steps. So, my lords, I believe that the depositions in the affidavit in opposition with reference to a subpoena, if my submission were right. Lords, there has been a submission which is to the effect that the way I cross-examined the first witness of the petitioner, I could only have gotten information from the chairperson of the first respondent. But my lords, if you go through the record, I used the witness's own exhibit D and E to make my analysis, and he admitted same. And Lords, regarding the evidence of the second and third witnesses of the petitioner, Lords, what they said, how they contradicted themselves is on the record. So the issue of the two different stories are for the court to determine. Very well, my Lord. Lord, I'll be ending soon. My Lord, I wish...
It's your time.
Yes, my Lord.
We are not even allotting time for counsel to be limited to within a very short time to present the submissions.
Yes.
So please try and organize yourself and present your case. That is all.
Yes, my Lord. I have addressed you on the abuse of process, and then I just wish to end, my lords, with the fact that a person summoned on a subpoena testifies in court as the witness of the party who caused the subpoena to issue. This application that serves as notice to your lordship that your court will be required to issue a subpoena for the first respondent to testify as a petitioner's witness. Again, my lords, it confuses our adversarial system of adjudicating.
If Mr. Chikata said the person will be an adverse witness.
Yes, but your ladyship,
hostile.
Yes, but definitely it is a party that calls a hostile witness.
So, Mr. Manobo, can you address us on section 26 of the Evidence Act?
Yes.
Which was agreed by...
Stop it.
Yes. My lords, with respect, section 26 that does not arise at all. Lords, if you go to section 24, we go to section 24. it says that where the basic facts that give rise to a conclusive presumption are found or otherwise established in the action, no evidence contrary to the conclusively presumed fact may be considered before the tribunal of fact. Then it is juxtaposed with section 26. It says that except as otherwise provided by law, including a rule of equity, where a party has by its own statement, act or omission, intentionally, deliberately caused or permitted another person to believe in a thing to be true, etc. Lord, a combined reading of these two do not support the petitioner's case one whit. My Lord, what are the presumed facts in this matter? The presumed facts, so far, the petitioner has been silent on. All he says is that, oh, I didn't anticipate that the first respondent will close his case, and therefore, I think that there are matters that will support my case, and therefore she should be called. That's it. It has nothing to do.
If I heard Mr. Chikata right, the presumed facts are that, one, in your statement of case, you alluded to the fact that the chairperson or the first respondent will make himself available for cross-examination, that he will testify. And then the other one was the averment in the position where she indicated the available.
That was why I was referring your lordships to the various rulings on the court that had determined the matter. But my lord said I should go to the sub. So it's my submission that the various ruling by the court for interrogatories, review, discovery, they have all addressed the matters that he is raising. That's my submission. Lord, on a lighter note, God is a God of conscience. My Lord, I believe that.
Ask him to go that far. This is in the court of law.
Yes.
Yes.
But my Lord, with respect, with the greatest respect.
When we come here and we take the oath and we swear on the cross or on the Bible, so be it. Yes.
My Lord, with respect, my counsel for the petitioner consistently made statements attacking the faith of the chairperson of the first respondent.
We corrected him. I think we corrected him that we are not here to demonstrate the faith of parties and witnesses.
Very well, my Lord. Yes. Yes. Lastly, it is my submission that no representation has been made whatsoever to the petitioner for which, based on that, he is bringing this application. Because I don't think that it is fair for the petitioner to blame the respondents rather than himself for the reason why his action had taken the stages that it took. Thus, I repeat that the first respondent is vehemently opposed to this application and prays for its dismissal. My Lord, I'm grateful to the court.
As I said, the application is directed basically against the first respondent. But since you were served.
Yes, my Lord, and I believe that the ruling of the court on the application.
It will affect the case in general. That is why you want to
materially our position in this matter. So we are entitled to give a full response to the application. My Lord, I wish to make a preliminary observation, submission, which is that ours is an adversarial system of litigation. It is not inquisitorial. Secondly, in that system of litigation, the question of burden of proof, the burden of producing evidence is fundamental. It's one of substantive law. And therefore, a party that bears the burden of proof and the burden of producing evidence, as the petitioner undoubtedly does, must effectively meet that burden of proof. And it is well established that where the party bearing the burden of proof and burden of producing evidence fails to meet these two burdens, the court has every right to dismiss the party's plaint, because the party's reliefs can only be obtained if it leads evidence that meets these two burdens. And it's our submission, my lords, that to date, the petitioner, in our respectful view, has failed woefully.
Are you addressing this?
No, my lords.
You are making a general. Don't go there.
I'm setting a foundation for my specific arguments.
These are general propositions of law.
Yes.
Yes. And credit us with that knowledge of the law.
Well, I wish to rely on my depositions, the depositions in the affidavit of second respondent in opposition to the petitioner's motion for leave to reopen the case. All the depositions. And my lords, particularly, I wish to refer your lordships to paragraph 12, paragraph 13, paragraph 14, 15, 16, and 17. My lords, it is our view that the general principle of law is that once a party to a suit announces to the court that he has no additional evidence to adduce and thus closes the case, the court is obliged to affirm that decision of the party. And my lords, we wish in that respect to refer your lordships to Lai versus Oforiwa, 1984-86, 2 Ghana Law Report, 410 at 427. It was a Court of Appeal case. Oforiwa, 1984-85, 2.
1984-86.
No, it's 84-86. 2 Ghana Law Reports, 410. A Court of Appeal case where at page 427, the court held that Learned Counsel submitted that the trial was unsatisfactory. For the learned trial judge closed the case for the defense when the cross-examination of the defendant's witness had not been completed. I think this is not a fair criticism of the Mary trial judge, for the record clearly indicated that it was the defense counsel who announced to the court that he was not calling further evidence, that was closing his case. In the circumstances, the court could not do otherwise but to accede to the request of the learned counsel and close the case for the defense. Counsel for the defendant contended that in any case it was wrong on the part of the counsel who appeared in the court below to have closed the case of the defendant at that stage, simply because the witness was not available for further cross-examination. But it seems to me that the learned counsel in the court below acted wisely and in the best interest of his clients, and that any counsel placed in the situation in which counsel found himself would have acted in similar manner. And Lord, it is our submission that it was counsel for petitioner who voluntarily announced to the court that he had closed his case. And Lord, he did so taking note of all the evidence adduced by his witnesses and through cross-examination of his witnesses. And Lord, that evidence included what happened in the strong room. The evidence also included the alleged conversation between the third witness of the petitioner and the chair of the first respondent. And it also alleged irregularities in the collation of results. Because the petitioner led all the evidence that it had in proof of these allegations through the three witnesses. Lord, he cannot, having led evidence that was within his knowledge, or that he could have, by exercising due diligence, obtained, now come back after closing his case to apply to the court to reopen the case, simply to leave further evidence on the same matters. My Lord, the petitioner also led evidence on what he considered to be unconstitutional actions, lack of transparency and fairness by the chairperson of the EC. Evidence was led on all these things. My Lord, so the question is, if the case is closed and the respondents elect not to adduce further, enter the box and adduce evidence, the question then is for the court to look at the evidence before it and determine whether or not the petitioner has led evidence to meet his claims and reliefs. And my Lord, it is important to underline the point that this has absolutely nothing to do with why the first respondent's chair does not want to enter the box. It is a totally irrelevant question at law. It is totally irrelevant. Again, it has nothing to do with the suggestion that the first respondent's chair must be pleased to have an opportunity to vindicate herself. Now, these matters are completely irrelevant to the application to reopen one's case and read what in effect is fresh evidence. Because the idea is to reopen the case, subpoena the first respondent's chair, so that he can lead further evidence. That is new evidence. And my lords, it is our respectful view, that the petitioner is bound to meet the time-tested conditions established by this court to lead new, fresh evidence. He cannot hide behind the application to reopen so as to subpoena, to suggest that this is not in substance an application to adduce fresh evidence. And if it is, as I think it is, then he must meet two basic conditions. One, that the fresh evidence that he is seeking to adduce through the subpoena was not available and could not have been obtained through due diligence. Whereas it's a submission that the proceedings of this court show clearly that the evidence on these four matters, what happened in the alleged encounter between the chairperson of the first respondent and the second and third witnesses of the petitioner, what happened in the strong room, the allegations of irregularity are clearly before this court. So it cannot be fresh evidence. Secondly,
it's not asking for fresh evidence. Please look critically at the motion.
He's seeking to reopen the case.
That's right.
So that he can subpoena. My Lord, and that is why, my Lord, with all due respect, that is why I think that the substance of the content of what he intends to achieve through the subpoena must be assessed, evaluated by this honorable court before it can decide whether or not to exercise its discretion in granting the application to reopen.
I think, Mr. Jesse, we heard him. Sorry, Mr. Kutampa.
My lords, my good friend Mr. Chachichikata referred to me as my friend Sheshe in the course of these proceedings.
So thank you. You see, I think he made a point that they want to reopen their case so that they can serve subpoena on on Mrs. Jane Mensah, so that she can be treated as a hostile witness. Yes. So address that, please.
Dr. Tampa, whilst you're addressing it, I also understood from him that you did some harm in cross-examination. You brought certain things out in cross-examination. So he should be allowed to speak to that through the process of the subpoena.
Yes. Our case is that at the time he was electing to close his case, he knew, the petitioner knew these new matters that were elicited from his witnesses were matters of record. And if he really intended to do that, he should have applied to the court to enable him to lead, to file a new witness statement, to lead evidence on that. He didn't do so. He had all the information at that time, and he boldly declared to the court that he was closing his case. The only reason why now the petitioner is applying to reopen his case is because after he closed his case, the respondents exercised a right that they had not to adduce any evidence. And my lords, counsel for the petitioner and the petitioner cannot say that they did not have an inkling of an idea that this was a possible approach that the respondents would adopt. First, because it is a process that is available in any trial for defendants.
Second, Mr. Akotonka, look at paragraph 16 of the affidavit in support. They said they were taken by surprise.
Yes.
By that year. Yes. It therefore came as a surprise, yes, that both counsel for the respondent announced on Monday in February 2021 that this was no longer the case. This was no longer the case. Paragraph 16 of the affidavit in support. Which means they had prepared to cross-examine, yes, your witnesses. And that was why they closed their case.
Yes.
They had no inkling whatsoever, yes, that you were going to close your case.
Yes.
And then this matter came to them as a surprise.
Yes. Well, if I may respond to that. My first point is that if they had thought through fully the case of the respondents, they would have known that this was very likely to happen. Because right from the beginning of our filing our answers, we had served notice to them and the court. But we didn't think that we had any case at all for us to be even heard. And yet, this honorable court, in its own wisdom, directed that you would deal with our preliminary objection at the end of the trial. So they must have had notice that it was likely, if they failed to lead sufficient evidence, that we will not adduce any evidence. And consistent with our original and primary position, we would ask the court to determine the matter and the evidence before it. So, it is, I cannot believe that my learned friend, Mr. Chachikata, would not have anticipated this matter as a matter of strategy. He should have, and if he didn't, well, my lords, that would be too bad for his client.
Mr. Kotankwa, if I recall, your submissions are already on file, aren't they? Your preliminary objections?
Yes.
They are already on record?
Yes.
Everybody's?
Yes, they've been served. Now, my lords, so that deals with the surprise. And my lords, again, it cannot be the case that they were relying on the statement made by chairperson of first respondent that even if the interrogatories fail, they would have an opportunity during cross-examination. That cannot be, as I've earlier stated, cannot be a commitment to the fact that we shall lead evidence to chief. It is only a legal argument that you may have that opportunity during cross-examination. And that opportunity will arise only if you enter the box to lead evidence in chief. So it can never constitute a fact under section, is it 25, 24 of the Evidence Act, upon which they acted to their detriment, and therefore we are estopped, or the first respondent is estopped from exercising his right not to adduce evidence. It cannot be. And my lord, what is even more interesting is that those provisions of the Evidence Act, my lord, we see that section 24 that he reads says that conclusive 24(2) reads, conclusive presumption include but are not limited to those provided in section 25 to 29. In my notes, if one goes to 25(1), it says, except as otherwise provided by law, including a rule of equity, the facts recited in a written document are conclusively presumed. Again, in 26, it said, as otherwise provided.
That's on 24 and 26. 25 deals with the contracts and conveyances.
Yes, my Lord, I'm saying that we will see these provisions must be read as a whole. You cannot take this out because section 26 again repeats the except as provided by law could be real evidence. When a party has by his own statement, act, or omission, intentionally or deliberately, caused or permitted another party to believe a thing to be true, and to act upon such belief, the truth of that thing shall be conclusively presumed. So there are exceptions in law and in equity. So it is not, and the same goes for section 27, 28, and 29. So my lords, I think that it is misconceived for counsel for the petitioner to suggest that the conclusive nature of the alleged statement of fact by first respondent is not limited in any way. And it is, in our view, limited by the right of the respondents to elect not to adduce evidence. My Lord, again, we wish to refer your lordships to the case of the president of the Methodist Church of Ghana versus K spelled K-Y-E. K-A-Y-E. Now, the president of the Methodist Church of Ghana versus K. My Lord, it's a judgment of the High Court, Cape Coast, by Owusu J. as it then was delivered on 10th April 1970. It's a one-page ruling, my Lord. 10th April 1970.
Is it in the 1970 current cases?
It's actually in the law reports 1970, but we couldn't.
1970.
Yes. Now we have the current cases.
Yes.
Yes.
Okay.
So, my Lord,
what did the court say?
Once a party closes his case, he abandons every right to call further evidence, except with the leave of the court. Precisely, that's why I'm saying that this is an attempt to call further evidence. That is the point I'm making, my lords. You know, and he must be held to the rule or the conditions to be met in order to adduce fresh evidence or further evidence, to use his words. Such an application is only considered when at the time of closing the case, no human ingenuity could foresee the existence of the particular evidence the party is seeking to adduce. That cannot be the case in this situation, my lords. Again, my lords, we also rely on Annabelle and Obosu and another, referred to by counsel for first respondents. And again, my lords, refer your lordships to the case of Combat versus Lambin, 1989. Sorry, my lords. Combat, spelled K-O-M-B-A-T, versus Lambin, L-A-M-B-I-N, 1989-90, One Ghana Law Reports, 324, where Benny J, as he then was, at the close of plaintiff's case, called a witness Somoto, who testified. Where the trial court
was it the Benny J who called? No, the trial court.
The trial court.
This was his civil appeal.
Yes. It was a trial court. Yes. After the case of the plaintiff's case, the trial court called a witness, Somoto, who testified in support of the defendant. And based on that testimony, the case of the plaintiff was thrown out. The plaintiff appealed against the decision of the court. The High Court, Quorum Benny J. Accident, was allowing the appeal, stated as follows. The general rule of evidence was that after a prisoner's case was closed, a judge should only call a fresh witness when a new matter had arisen ex improviso, which would not have been foreseen. Such a witness could, in civil cases, only be called with the consent of all the parties. Let me emphasize, with the consent of all the parties in civil case. My lords, we believe that the authorities in Canada, Commonwealth jurisdiction, may, with respect, assist your lordships. And we wish to refer to the case of Ontario Limited versus Sagas Industries, Canada Incorporated. It's a 2001 SCC 59 or 2 SCR 98. That's the Supreme Court of Canada. There, the High Court approved of the two-stage test first articulated in the case of Scott versus Cook, 1970, OJ number 1487. Namely, the test which is intended to assist the trial judge in exercising his or her discretion to reopen the trial requires the moving party, one, to show that the evidence he or she seeks to adduce is such that if it had been presented at trial, would probably have changed the results. And two, prove that such evidence could not have been obtained by reasonable diligence before the trial court. Now, these are the same principles that this honorable court applies in adducing fresh evidence. Now, my lord, it is our submission that this case is about votes and numbers. My lord, there is nothing about the engagement between the second and third witnesses of the petitioner, alleged engagement with the chairperson of first respondent. Even if true, that has been shown to have had any material effect on the outcome of the elections. And we demonstrated that quite thoroughly during our cross-examination of Mr. Asiedin Ketia, where we took him through all the different stages to show that no matter what you do, first, second respondent cross the 50+ threshold, and petitioner persistently remained around 47%. So, and truth be told, the third witness actually declared during cross-examination why they were going to see the petitioner. That was it. They were going to tell him about the irregularities and errors in the collation process. And the question is, does their claim of irregularities and errors in the collation process legally stop the EC and the returning officer of the presidential election from exercising her independent function and duty to declare election results if, in her view, the election results were accurate? The only thing that the petitioners could do would be to come to court to demonstrate that the election results were not accurate. So, my lords, one cannot fault the EC chair until you come to court and are able to show that the election results were not accurate. And
please address us on the general principles which you base your submission on the authorities. Yes. The EC on record is not your client.
I'm a bit taken aback.
In opening the case, we have serious consequences on the case because both of you may do so many things. But for the time being, yes, the application is for the reopening of the case for the petitioner. Yes, and your attention has been so much on the first respondent. And I'm saying that on record, they are not even saying that when the case is reopened, they will subpoena the second respondent to mount the witness box.
That's exactly what they said.
So we want you to address us on why the reopening should.
Very well.
Yes, I think you have to understand the bench.
Very well.
Yes, because they are not asking for anything from the second respondent.
Very well. My lords, my simple submission is that to reopen, they must satisfy the two preconditions. One, that the evidence they intend to lead was not available to them at the time they closed their case and could not have been obtained by the exercise of due diligence. Yes. And two, that the evidence they intend to adduce, if they are given leave to reopen their case, will have a material effect on the case. And we are saying that there's no way that it will have a material effect on the case, given the evidence before the court. Even if they use her as a voter witness. Even if they choose to use her as a holster witness, my lords. My lords, we also wish to refer your lordships to the off-quoted case of Dombo and others, which is now 1970 CC 68, a Court of Appeal case. And then...
That's fresh evidence on appeal.
Yes.
Yes, an appeal. So the principles are never the same. Adduction of fresh evidence on appeal has nothing to do with reopening of a substantive case at the trial court. Yes, to make, or to reopen and...
My lord,
please.
My lord, the principles apply in pari materia. That is my submission.
Not only.
And the principles apply in pari materia. You know. And my lords, 68, the Court of Appeal decision. And my lords, again, in Poku versus Poku, 2007-2008, 1996. Supreme Court of Ghana report, 1996. 996, sorry. Now, my lords, it's our case that the decision of the court in Poku and Poku, even though referred to adducing fresh evidence on appeal, are the same in the case where a party closes his case and applies to reopen his case to adduce further evidence. They apply pari materia. And in that case, would CJ observe as follows at page 1015. Consequently, the invariable rule, as I understand it, is that in an application to lead fresh evidence or new evidence, the first criteria which an applicant ought to establish is whether or not the evidence sought to be adduced was not in the possession of the applicant party, or was not obtainable by the exercise of reasonable diligence or human ingenuity before the impugned decision was rendered. It is only when this first hurdle has been surmounted that the court should proceed to determine the other pertinent question of whether or not the intended evidence would have a positive effect on the outcome. Stated differently, if the first criterion is not met, no useful purpose will be served by examining the other factors. And my lords, into our submission in respect, if I may make submissions on the question of subpoena, or it is not a matter before your lordship. In other words, it is our submission that the application of the 65 Rule 4 of the High Court rules, CI 47, 6, Order 35, Rule 4. Yes, Rule 4. States thus, the writ of subpoena ad testificandum, or writ of subpoena duces tecum, to compel the attendance of a witness for the purpose of proceeding in chambers will be issued out of the registry if the party who desires the attendance of the witness produces a note from the judge or a register authorizing the issue of the writ. Further, Section 88(1) of the Evidence Act 1975, NRCD 323, provides inter alia that except as otherwise provided in this part of Evidence Act 1975, states inter alia thus: except as otherwise provided in this part or in any other enactment, no person has a privilege to refuse when duly subpoenaed to be a witness. Now, my lords, the petitioner applied to this court to open his case and to issue a subpoena to compel the chairperson of first respondent to testify. My lords, this should be viewed, this application should be viewed in the peculiar circumstances that first respondent has already elected not to adduce any evidence in this petition. And the court has affirmed its right not to adduce any evidence. My lords, the process of cross-examination involves adducing evidence. And so, my lords, it's our submission that the object of this application to reopen the case is precisely the object of their opposition to the respondent's election not to adduce evidence. And it is our respectful submission that the court, having upheld that right of the first respondent and the respondents generally to elect not to adduce evidence, cannot with one hand affirm that right and with the other hand disaffirm it by allowing the petitioner to subpoena him, to cross-examine him, and thereby adduce evidence from her. And I think that will be inconsistent with the court's own ruling.
Mr. Akutuampa, based on the submissions you've just made, what would be your comment on paragraph 15 of petitioner's affidavit in support?
Yes, paragraph 15, my lord. Yes, my lord is saying that it has become necessary. My lord, we say that they have demonstrated absolutely no necessity. My lord, the petitioner has demonstrated no necessity. Because, with all due respect, they have not shown how the grant of the application would have a material effect. That's the necessity. Material effect on the outcome of the matter in dispute. They have not shown it. All that they have said is that the EC has a constitutional role. It has to be accountable. The chair of the EC has to be accountable to the people. So, and their lawsuits, in their ruling, said that the rules that apply to ordinary people in these circumstances equally apply to the EC chair. That's what your ruling a few days ago stated. So, my lords, we do not see that they have demonstrated any necessity. All the necessity is based on the fact, the allegation that the chair of the first respondent is stopped from saying that he will not enter the box because she had already committed herself so to do. When the chair of the second respondent never ever committed herself to that, and cannot thereby be stopped. Lords, we would with respect and with and with two other cases. The first is the Northern Ireland case of Ryan Andrew Fulton and Miss Fulton and Cyril Fulton. Sorry, Ryan, R-Y-A-N, Andrew, and Fulton, F-U-L-T-O-N, and Miss Fulton and Cyril Fulton versus AIB Group UK PLC 2017 Mika 42 2017 WL 03382220.
WLR or WL?
No, that's WL. L, that's all. Zero. At page 5.
You said 0, the citation.
The citation is, the first one is NICA 44.
Oh, okay.
Yes, 44. This was a case where in the court below, the High Court judge refused an application for discovery because it did not satisfy the two important tests of disclosure, which are necessity and relevance. And my lords, in your ruling on discovery, you upheld these two cardinal principles, necessity and relevance. The applicant's appeal was accompanied in the case by an application for subpoena against various people, including counsel for the respondents, to produce discoverable documents. The court, Gillian LJ, dismissed the appeal and disallowed the subpoena application, stating emphatically in its judgment thus: suffice to say that we are satisfied that the application in front of McBride J for discovery was correctly decided by her, and we affirm her decision. And this, my lords, is the important statement of the law. Accordingly, we also come to the conclusion that there is no basis for the subpoenas now being sought, as they arise out of the claim for disclosure. If discovery is not appropriate, then subpoenas are not appropriate.
Well, Mr. Kotopa, what's the relevance of this case to the present application? You are now dealing with subpoena and discovery. We've gone past that. We are now dealing with an application invoking our inherent jurisdiction to reopen the case.
Yes. But the reopening, my lords, relate to the substantive issue of the matters they sought to elicit.
As at length on the reopening. My brother is just asking you how that case bears any affinity.
No, because my lord, there's a principle that a request for subpoena cannot be used to disguise an application for discovery. That's the principle of law.
No, come again.
A request for subpoena cannot be used to disguise an application for discovery of document.
No, but you've gone beyond discovery, and these are earlier interlocutory applications which we disposed of several weeks back.
Well, our understanding of this process in the circumstances of this trial is that they are seeking by their subpoena to elicit the very information that they failed to elicit in the application for discovery. And I'm saying that the principle is that what you cannot get by discovery, you cannot use a subpoena to get. That is the point. And my Lord,
according to you, or according to them, their submission, you give them the promise that you don't need the discoveries. You don't need the discoveries because you'll be available to testify, and they can ask these questions when you are in the witness box.
My Lord, with all due respect, we never made any promise. We just stated the position of the law that a matter that you may not obtain through discovery, you may elicit through cross-examination. That is all. We're not saying that we are promised to enter the box, because the time had not arisen for us to adduce Mr. Elect.
You did not make that promise. Yes, we on record, it is there. But yes, because
my Lord,
and also you are not appearing for the first.
Yes, my Lord. Yes, that is true. But
is it free legal advice?
My Lord,
are you going to be paid?
I'm a party to this case, and as counsel, I have a duty to this court to draw its attention to the correct position of the law. Yes. So it doesn't. I think that it doesn't matter too much that I am not counsel for first respondent. Yes. So, my Lord, the last case was, I wish to refer your lordships back again to the instructive words of Ruth C.J. in Poku and Poku at page 998. The learned Chief Justice then admonished with great emphasis that, quote, an application to adduce fresh evidence is clearly circumscribed and only operates within its statutory limits. This rule is therefore intended to assist an applicant who has made a genuine attempt to look for evidence and has met with failure. Courts ought therefore to be adept at unmasking attempts by a dissatisfied party coming through the back door under the cloak of having come by new or fresh evidence, seek to fill in the gaps or lapses in his or her case. For the rule is not meant to aid the slothful or the indolent, the careless, negligent, or reckless litigant, whether acting pro se or through counsel. The application is not granted on compassionate grounds. Why is it that the EC, God, and so on should not go into the box? Those are not the grounds. Neither is it meant to give slovenly, particularly a litigant acting through counsel and who fails at the trial to marshal his facts carefully and fails to conduct his case properly by presenting essential evidence at the trial or through the necessary cross-examination, or also fails to conduct the necessary investigation which would have thrown light on the strengthen his case, a second chance at rebuilding his or her case. Under such circumstances, an unsuccessful attempt to lead fresh evidence cannot be met with the criticism that the court was visiting the iniquities of counsel on the client. Either for the law has made provision for redress where the loss of a suit is the direct result of recklessness or negligence of counsel. And it closes. A party who goes to court has the sole burden, let me emphasize, the sole burden of leading sufficient evidence to prove his case. He cannot rely on the weaknesses of his opponent or rely on his opponent in prosecuting his case. And it is for this reason that Sarkodie in Berima Jamfi and another versus Bedu, 1963, 2 Ghana Law Reports, 596. The Supreme Court crowned Sarkodie Ado, Olemu, and Blade JJSC. Speaking through Olemu JSC, Ozel, at page 597 as follows. The plaintiff could not have called any of the other eyewitnesses because they were the very people against whom he was litigating his title. And it would be nothing but madness for a party to seek to rely on his opponents to prove his case. My lords, we lost our case.
Mr. Akutampa, I think you have to change your wig. It has lost its identity as a wig.
My lord, it gives it unique identity.
Lord, may I, with your leave, just make one short point in response as a matter of law. And my Lord, I just wish to point out that we could not, at the time we closed our case, as a matter of law, we could not have subpoenaed Mrs. Jean Mensah because she had a witness statement that she had filed in this court on behalf of the first defendant, the first respondent. That witness statement was in this court in addition to the affidavit that I referred to. So at that point in time, we could not have subpoenaed her.
Mr. Chikata, just one. Flowing from the submission from counsel, in these proceedings, this court has upheld the right of the chairperson or the first respondent not to testify.
No, my lord.
By our ruling, let me land. We have confirmed her right to decide not to testify. So don't you think that there's a judicial bar as far as this proceedings is concerned?
My lord,
for her not to testify.
No, my lord, no. What your lordships ruled on was the right of the first respondent not to adduce evidence.
Yes. That is representing the first respondent.
No, my lords, respectfully, the returning officer of the election is an individual. The first respondent is the commission. Now, and that is why respectfully I made the point that as a matter of law, at the point in time when we closed our case, we could not have subpoenaed her because at that point in time, she had put in a witness statement on behalf of the first respondent. So the only point at which the matter changed would necessitate, that's the necessity in paragraph 15 that we're talking about. The point in time at which that situation changed was when it was indicated that despite the earlier election to adduce evidence, there would no longer be evidence.
My lords, with all due respect, this court has ruled that the first respondent never elected. So, counsel cannot be speaking to the same court and suggesting that she elected. We have to be faithful to the record of the court. Well, the public is also listening, and they can be misled.
You see, the point I'm making is that in our ruling, we specifically say that the chairperson of the first respondent has a right not to adduce evidence.
Not to adduce evidence. That's what your Lordship just said.
Yes.
In other words, I mean, you were speaking about the first respondent as first respondent. That's the electoral commission.
No, the chairperson.
Also specific.
The chairperson.
The chairperson of
the first respondent. In fact, she put in the witness statement, as you have been referring to.
Yes.
And those affidavits were deposed by her. And so we said that specifically the chairperson of the first respondent cannot be compelled to adduce evidence. So don't you think that there's a judicial bar? And for that matter,
there's a judicial bar. There's a judicial bar.
And for that matter, she cannot be compelled through any other means to testify in these proceedings, so long as these proceedings are pending.
My lord, of course. I mean, you know, we have every right to seek a review of that ruling if the interpretation that you're giving, if the interpretation of that ruling that you're giving is right. But the point that I wish to emphasize is that our understanding of the ruling, especially in the context of the orders, the order 38, CI 87 issues, that in that context, our understanding of that ruling relates to the fact that the first respondent has it within their rights not to call a witness. I mean, just all the authorities that your Lordship cited in the ruling were about the right of a party not to call a witness. That's nothing more. That's what the authorities that were cited were about. So a party...
Respectfully, the last but one page.
I'm sorry.
The last, I don't know whether you have a copy of the ruling. It is annexed to the affidavit of the second respondent. Yes. Unfortunately, they did not indicate the page, but it appears the last but one page.
The affidavit of the second respondent.
No, the rule is annexed.
Yes.
Yeah, it's annexed to
the...
Yeah.
Yes.
Yeah. I think the last paragraph, beginning with, the law is therefore settled that a party will not be compelled to enter the witness box and testify in support of
a party. The chairperson is not a party.
Parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the Society of Lawyers case to the peculiar facts of this petition because the first respondent, being a constitutional body with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Lawyers case, like this petition, also deals with witnesses who have served witness statements and have decided not to give evidence to be cross-examined. Indeed, the witness statement was served by Mrs. G. Mensah.
Yes, but my lords, a party, your lordship just read a ruling in which your lordship referred to a party. The party in this case is the first respondent, not Mrs. G. Mensah.
Yeah.
And we are saying,
under the circumstances, you declare the results from the Electoral Commission.
My lords, that is a perfectly legitimate legal separation. The EC is a corporate body, and the returning officer is an individual who happens to be the chairperson of that corporate body. You cannot, with respect, you cannot make the two identical. My lords, otherwise, why would the Constitution make the returning officer the chairperson, not the whole EC? The Constitution is quite clear in separating the role of
appreciate that. But then it is the commissioner who declared the result.
The chairperson, in her distinct capacity as chairperson, not the EC. So, I was just responding to the point about, lack of due diligence and so on and so forth, and I was just pointing out that at the point in time when we closed our case, there was a witness statement signed by the first respondent. That is our submission. That witness statement, yes, that's all.
ASAASE Radio. ASAASE Radio.
By court, this petition is served urgent to tomorrow. That is Tuesday, the 16th of February, 2021, at 10 o'clock. Please, it's 10 o'clock a.m.
With all due respect, I have a little prayer to make. My lords, this court directed us last week that we should all file our written closing arguments.
There are other things.
If my lordship will hear me out, if you, by Wednesday, simultaneously, my lords, we have seen a situation where the court has ordered parties to file their witness statements by a certain date, and others apply for review and use it not to file, with the effect that we file our witness statements before they file. And I just want to pray for an order to the registrar that if we file our witness statement on Wednesday and the other party has not filed closing addresses, and the other party has not filed because of maybe a review, we should not have any sight of our closing address. Yes. Well, that's our prayer. I think it's important to give integrity to the order of the court that all parties must file on Wednesday simultaneously.
As your lordships have indicated, this is a court of record. If he wishes to make an application in respect of the order.
So you're still here on ASAASE Radio 99.5 megahertz. We've been bringing you the live happenings in court in respect of the 2020 election petition. The court has adjourned to tomorrow, by which time they are expecting to make their ruling in respect of the application by the counsel for the petitioner to be able to subpoena the chairperson of the Electoral Commission